It's time to turn to final reflections because we're running out of time. So I have to just turn to the panel to give us a little bit of snapshot in our last 5 minutes of what we saw this term and what we're likely to see next term. What are the big takeaway observations? And Tom Goldstein, if I can come first to you, if you're done listening, could you just give us, since you are to all of us the keeper of the statistics, the watcher of the trends, can you give us a quick overview of what the big trend was this year, what you see for next year, and then we'll go to the panel for each one to give a takeaway on this term.
Well, I don't think that the term was all bad news for progressives, and so I don't want people to take away from this the sense that it was a loss across the board. There is statistically one very significant and positive development, and that is the court this term decided only 68 cases. Which is
a third of what it was doing at the height of the Warren Court.
The docket is down. I don't think the court is trying to get out of the business of deciding cases, but for a variety of reasons is deciding fewer, and will decide probably a still very low number next term. Justice Kennedy is having the greatest week ever. As of today, with the end of the term, there were 24 5-4 decisions. He was in the majority of all of them. There were, if you count the schools cases just as one case, 24, half of them, 12, were decided 5-4 with Justice Kennedy joining the more conservative majority, and those were the most significant cases, Massachusetts versus EPA being really the only genuine counterpoint to that. In terms of voting and how the justices, the alignments worked out, the justices that had the closest voting patterns were the Chief Justice and Justice Alito, really showing that they really have very similar views. When there were divisions among the conservatives, it tended to be the questions of degree that we've talked about, with Justice Thomas in particular being the most willing to rethink precedent fundamentally, Justice Scalia to a lesser extent but still significantly, and Justice Roberts and Justice Alito, the Chief and Justice Alito, getting to the same result but by a more incremental step. Next term, very briefly, we do have really a very fascinating case involving the 100-to-1 ratio. Crack versus powdered cocaine is probably the biggest case, and also the Vienna Convention case. Medellin is back in the U.S. Supreme Court, which involves when foreign nationals are in the U.S. courts, and in particular in capital cases, when it is they have to be put in touch with their counsel, their consul. And so I would say that what we're probably going to look back on this term as if it were June 15th, 1961 in reverse. And June 15, 1961 was the day that MAP in Ohio was decided. And it was, in effect, sort of the birth of the Warren Court era. It was decided by a 5-vote majority. They overruled Wolf versus Colorado and applied the Fourth Amendment to the states. And it started a whole trend of a series of cases from Reynolds and Sims to Frontiero, all of the major doctrines that law students today think of as if they were written into the Constitution had their birth at the end of the term in 1961. The court can really only go to the right from here in terms of what you would expect in terms of retirements, and so it is very unlikely that we will start heading back to back to the left in any significant way. And so it may be the birth of an entirely new jurisprudential era.
Mike Carvin?
Yeah, I mean, I certainly appreciate the statistical analysis, but at the end of the day, you just need to count to 5, right? So everybody knows that Kennedy is the court now. It used to be Kennedy and O'Connor. For people who you folks would call conservatives, I would call people who believe in the rule of law. You used to have to get 2 votes. Now you need to get 1 vote. And because of that, I think it's very difficult to trend out or postulate about where the court's going. I think that through a confluence of events, this term represented some issues where Kennedy I would say, solid, you would say is misguided on. In the affirmative action, really all the race cases, I think he's been siding with Scalia and Thomas typically. First Amendment campaign finances, he dissented in McConnell, he dissented in the partial birth cases. So I think this was a case that presented an opportunity to trim back on what I'll call the excesses of recent terms in a way that appealed to Kennedy. But if you get a different alignment of cases, the kind of Bowers v. Hardwick sort of issues and those sorts of things, then I think you'll see the court not changing gear or moving left. And so it's all up to him. And the other thing that I don't think he got a tremendous amount of insight this term, but I think that it'll be very interesting over the next few years to see how this incrementalist salami slicing approach that Roberts seems to be embarking on compared with the more blunderbuss approach of Scalia plays out. I think that may well be context specific as well.
Okay. Walter Dellinger.
I just think the term will be marked by two cases that are tragically, historically tragic decisions. I think the court has turned the corner on a jurisprudence that saw government control of women's reproductive lives as a totalitarian intervention, and was at the core of what we think of as liberty. And I think the school decisions is historically misguided because they conflate two uses of race that are so fundamentally different in such a hyper-technical and way that belies common sense. That Brown condemned a system of Southern racial apartheid, of domination and subordination. The people of Louisville have worked together to try to come up with a system to keep people in the public school system. They've refused to give up on their public schools. They've worked across racial lines. They know that they're building upon a system of residential segregation, which was created by federal, state, and local governments. And they know that just to choose that would be to perpetuate segregation. They've tried to bring the races together in the public schools, and that's not the same thing that the court condemned in Brown.
Okay. Drew Days.
Two things. The court hasn't acted on the Guantanamo detainees case, but we'll see if that is accepted for review, how much this court believes in the rule of law, because I think habeas corpus is one of our greatest rules of law in America. The second thing is to follow Walter. It remains to be seen what the court has offered as alternative ways of dealing with what continues to be a profound problem of racial segregation in our society and in our schools. The record reflects that so-called alternative means have simply not worked. So I wonder if the court is offering a hollow alternative to something that really needs to be dealt with quite directly.
Pam Carlin.
Well, this term we saw the court announce the First Amendment applies to corporations in Wisconsin Right to Life, but not to students in the Bong Hits for Jesus case. We saw the court announce that we should be deferential to state trial judges in criminal cases, but not to democratically elected local school boards in the schools cases. So if this is the birth of a new constitutional era, all I can say is what an ugly baby.
Ladies and gentlemen, when you leave the building, especially those of you who are students, do not hold up any 14-foot banners saying Bong Hits for Jesus. We don't know what it means, but whatever it means, there's no free speech right to say Bong Hits for Jesus, because in one case we didn't get to this term, the court ruled that schools may discipline a student for drug use-inducing speech, which was a correction to earlier cases upholding student speech rights. Ladies and gentlemen, please join me in thanking this wonderful panel for today's discussion.